Good evening, everyone. Today we have Advocate Nitish Bagri, who is a Supreme Court advocate. He has, in his previous past years of practice, he has practiced under various law firms. Now he runs in his own independent law firm by name NBA Legal Consultants in Jodhpur and Jaipur. Earlier, he was also a panel lawyer for State of Rajasthan in 2015. He has represented State of Rajasthan before Supreme Court of India. He has guided, strategized, and appeared for media houses, newspaper publications, EPC companies, real estate companies, and insurance companies in various forums for disputes pertaining to arbitration, commercial negotiations, and civil litigation. So, under civil litigation, consumer forum is also one of the practice area. Today, we'll try and explore through Advocate Nitish how the scope of practice before consumer forum exists for all budding lawyers, and what type of complaints can be filed, what is the jurisdiction. We'll try to understand through Nitish sir. So Nitish sir, I hand over the stage to you. We welcome you. We thank you very much for this opportunity from your side to give us a seminar on the consumer forum. We welcome you, sir. We thank you. Yeah, the stage is yours, sir. Yeah.
Thank you, Abhilash. Thank you for such a wonderful introduction.
Yeah.
Hello, everyone. I'm Nitish Bagri. Today, I'm here to speak on the issue of consumer laws. So, my segment would be divided into three parts: pre-1986, from 1986 to 2019, and 2019 onwards. These are the three stages in which the consumer laws have evolved in India. So, pre-96. What happens was there was no specific laws for consumers. Consumer litigation or the consumer disputes was as good as a civil dispute, which were triable by the magistrate or the district judge in according to the pecuniary jurisdiction of different states. You need to file a civil suit before the concerned court. It will be as good as a civil trial. There will be evidences led by both the parties. Cross evidence would be done. Then against the order of the concerned judge, first appeal was a matter of right. So it would take almost 7 to 10 years for one consumer dispute to be decided. So in a longer run, the whole viability or the whole sense of consumer benefit lost its sight. So this was happening across the world in almost every jurisdiction, since there was no specialized forum for dealing with the consumer disputes. The United Nations in 1985 adopted the guidelines through the General Assembly on the consumer protection, which broadened the scope of, I would not say broadened, I would say that it started the scope of consumer laws in various jurisdictions. Since India was the charter member or the full-time member to the United Nations, it had to adopt to the guidelines which were provided by the United Nations, and due to which the Consumer Protection Act 1986 got enacted. Consumer Protection 1986 was the Magna Carta for the consumer laws in various or among the various countries of the world. And it was the most powerful legislation, or the India had the most powerful consumer legislation in 1989. Consumer Protection Act 1986 was a three-tier system. It had three forums for addressing the issues of consumers. First was District Forum, second was State Commission, and the third is National Consumer Commission. So District Forum consisted of a retired judicial officer, two members of which one would be women and other can be a male, who would hear the matter. This bench of 2 to 3 persons would hear the matter. The pecuniary jurisdiction before the District Consumer Forum under the Act of 1986 was up to the dispute of 20 lakhs. So if there is any dispute up to the range of 20 lakhs, it could be filed before the concerned District Forum. District Forum would, the jurisdiction of Consumer Forum would be decided from the compensation you are seeking. It is not from the amount which you have paid to obtain services or deficient or product. the claim which you have sought would be the amount, would be the qualifying amount to get the jurisdiction decided. So up to the range of 20 lakhs, the amount, the claim could be filed before the district consumer forum. The method or the procedure is a very convenient method. There is no cross examination. You can either be represented by yourself or through consumer associations or through advocates, where you can file a complaint. After in the complaint, once the reply is filed, evidence affidavit is filed by both the parties and the matter is argued finally. First appeal is not a matter of right. So the consumer legislation intended to reduce the timeline of a civil dispute in particular consumer cases. Now, what is consumer cases? In what matters consumer cases can be filed? Consumer cases can be filed in basically two situations: when there is an unfair trade practice or there is a deficiency in goods and services. So unfair trade practice is supposedly there is a maximum retail price which has been fixed for say 100 rupees, and that particular shopkeeper or a company is charging 120 rupees from you for getting that product or for getting that services. So that is an unfair trade practice. In the deficiency in goods and services, so supposedly you have purchased an X quality of good which has been assured benefits or assured usage for say 2 years, and that product breaks down in 3 months. So that is an unfair, that is a deficiency of goods and services. Or you have been assured, so supposedly you have assured a service that your goods should be transported from city A to city B in 3 days, and that good transportation took almost 10 days. So this is a deficiency in services. So in both the cases, that is unfair trade practice. Second, deficiency in goods and services, consumer complaint is maintainable. The exception is that commercial matters cannot fall under the consumer protection law. So you cannot derive profits out of this whole transaction. So the example is that I bought a product for 80 rupees and sold it for 130 rupees and found out that there is a deficiency in good, or there was an unfair trade practice which I succumbed to. Then I cannot file a consumer complaint because I had ultimately sold it for monetary benefit. So therefore, in those matters or the commercial matters, the Consumer Protection Act is not maintainable. Another exception to it is if that is done for earning livelihood. So supposedly, if I run a garment shop and I have bought a garment from a company to be made as a shirt, but that garment quality or that quality was not fine. So since I was doing it to earn my livelihood, I would again fall within the definition of consumer under the Consumer Protection Act 1986. There is a very thin line difference between commercial matters and consumer matters. So that thin line difference has to be very perfectly stated, that if you are filing a case, you have to very categorically state in your complaint that this whole transaction was done either for earning livelihood or for self-consumption, and therefore it is not commercial in nature. Second, the timeline or the procedure in the district forum, state forum, or the national commission under the Act of 1986 is very simplified. So once the complaint is filed, notices are issued. After the notices are served, within period of 30 plus 15 days, I would not say it directly as 45 days, I would say 30 plus 15 days time was granted for filing of reply. So the 30 days is the normal period for filing reply, and in case for any reason the reply could not be filed in 30 days, with the permission of the concerned forum, additional 15 days period could be granted for filing reply. Beyond this 45 days timeline, the reply cannot be accepted and the matter would be heard at the next stage. And once the reply is not filed, evidence would also be not read, and ultimately the consumer complaint would be allowed. So this timeline of 45 days was prescribed in the Act of 1986 so as to reduce the timeline for this dispute or the litigation to go on. because once the reply is filed within a period of 45 days, consumer or the complainant would immediately file its evidence, and at the maximum 1 or 2 opportunities may be granted to the respondents for filing evidence affidavit, and ultimately the matter would be heard. So keeping this in mind, this timeline of 45 days was fixed under the Act of 1986. Thereafter, once the evidence affidavit is filed, there is no cross-examination. Cross-examination can only be done with the prior permission of the concerned court. So normally, in 99% of the circumstances, the cross-evidence permission is not granted. The matter is decided, since it is a summary trial, the matter is decided solely on the basis of the evidence and the documents which we have submitted. And after evaluating the various judgments of NCDRC and the state forums, the compensation is awarded. Now, the compensation can be in 2 forms. Compensation can be in form of payment, compensation in terms of money. Second, replacement of products. So just in case there is a product liability or there is a product deficiency, the state commission the concerned forum can certainly direct to replace the product, and also give you some mental agony compensation or the physical harassment compensation. Otherwise, if the product it cannot be changed or cannot be replaced, or there is no viability of replacing that product, they can award you the total amount of compensation up to the quantity, up to the price of that product and the quantity you have purchased. So mental harassment and physical harassment compensation part is also included in the final award. Litigation costs are awarded separately, and on these 3 counts, the compensation is calculated. Now, the appeal from the order of district forum lies to the state commission. If the original complaint is before the state commission, the appeal shall go to the national commission. And if there is the original complaint is before the national commission, the appeal would go to Supreme Court. So the appeal needs to be filed within a period of 30 days under the Act of 1986. So if the appeal is not filed within a period of 30 days, it has to be annexed with an application under Section 5 of the Limitation Act, saying or describing the reason for delay in filing an appeal before the state commission. Normally, in a civil litigation, appeal is a matter of right. It is admitted, and then it is heard after 3 to 4 years or 5 years, whenever the numbers come, according to the pendency of cases in different forums in different states. In consumer laws, appeal is not a matter of right. It will be heard on admission. If there is any grave error apparent on the face of record, or there is some factual aspect which has been overlooked by the immediate lower forum, only then the appeal would be admitted and notices will be issued. Appeal will also be filed only when 50% of the amount or 25,000 rupees is deposited as a court fee. So if you are filing an appeal before the state commission against the order of a district forum, either 50% of the amount or 25,000 rupees, up to the maximum of 25,000 rupees is to be deposited, only then the appeal would be entertained. Once the appeal is decided, in either ways allowed or dismissed, there is no remedy of second appeal. A revision is maintainable before the next forum, that is the National Commission, and that is only in the rarest of rarest circumstances where there is an illegality on the face of record not dealt by both the forums, that is state commission and district forum. Only then the revision petition is entertained. It is like 1 in 100 cases the revision petitions are maintainable before the national commissions. Otherwise, it is not maintainable. And so how, once the award is obtained, you can also file an appeal if you are dissatisfied with the order of the concerned district forum or the state commission that the compensation was awarded less. The timeline would be the same, that is 30 days for filing of appeal. Now, when you got an award or got a compensation order from the concerned forum, how do you implement it? So, not implementing the orders of the concerned consumer forums is a punishable offense with the imprisonment of 3 years. So the concerned district forum or state forum or the national commission is empowered with with the powers assigned to a magistrate, and this non implementation or non compliance of the order of the concerned forum is a punishable offense under section 27 of the Consumer Protection Act. Now I would say, what is the pecuniary jurisdiction part? So pecuniary jurisdiction is for cases up to 20 lakhs, the matter would go before the district forum. From 20 lakhs to 1 crore, the matter would go before the state forum or the State Consumer Dispute Resolution Commission. And if the matter is above 1 crore, it would go before the National Commission. This is under the Act of 1986. This has been revised under the new Act of 2019. Why I am focusing more on the Consumer Protection Act 1986 is that major complaints till today in almost all jurisdictions of India is majorly on the Consumer Protection Act 1986, and the Act says that the complaints which has been filed under the previous Act would be dealt under the procedure prescribed under the previous Act. That the new Act would not be applicable. So it is important to focus on the Consumer Protection Act 1986, and even the Consumer Protection Act 2019 has more or less its basics from the Consumer Protection Act 1986 itself. So when I've told you that these are three jurisdictions. Now, how the jurisdiction is determined? So whatever you seek, the compensation is the pecuniary jurisdiction in which you will be filing your consumer complaint. So if you seek a compensation up to 19 lakhs, the matter would go before the district forum. If you seek compensation up to 80 lakhs, you would go before the state commission. Supposedly, if you seek a compensation of 1.5 crores, you would go before the national commission. So this is the method, or this is the procedure for filing of complaints according to the pecuniary jurisdiction under the Consumer Protection Act 1986. Now, who would be the members or who would be the presiding officers of the State Commission? State Commission is headed by the chairman, who will be or is serving as the sitting judge or a retired High Court judge of the High Court judge of the Indian High Court, any Indian state's High Court. The term would be for 5 years or until he or she attains the age of 67. The other benches would be 50% compromising of the judicial officers and 50% from the socio-economical background who have deep interest in or who have experience in the consumer field. It can be from voluntary consumer organizations, voluntary government consumer NGOs, other consumer right wings. In these kind of people can also be appointed on these posts. Now, how these appointments are made? Before the district forum as well as before the state commission, the appointments are made by a selection committee comprising of principals of the principal secretary law, principal secretary food and consumer affairs. In case of district forum, it would be president, it would be the chairman of the state commission, and in case of the appointment for chairman, it would be the chief justice. So these are the persons who would be sitting for appointment of the persons in the concerned forum. Now, it is very intriguing aspect that why consumer litigations are still there. Are a lot of consumer litigations which has been pending in various jurisdictions. The only issue is that the Consumer Protection Act 1986 is a very sound and very most balanced and powerful legislation of that particular time. The problem is with the infrastructure. The infrastructure has not been properly assigned to the district forums or state forums in order to deal with all the consumer litigation at a fast pace. That is why there is still delayed adjudication in the consumer litigation. But hopefully, I think after the enactment of this Act of 2019, there will be a better result, or there will be a quick redressal of all the litigation which is pending. Now, from 1986 to 2019, this Act of 86 served its purpose. Since the technology has evolved, the method of engagement in business has evolved. So there was a need felt to either modify or amend the legislation of 86, or repeal the act, or bring in a new act, because it would not cover the issues of e-commerce. E-commerce is basically a three-tier system. A person is selling the product, B person is facilitating the transportation, and C person is the actual owner, actual user of the product. So the Consumer Protection Act 1986 did not cover this three-tier system. And even otherwise, after the adaptation of technology, there have been a lot of changes in how a business deal, or how a consumer deal or consumer issues are going into places. So the Act of 1986 was revealed in Consumer Protection Act 2019 was enacted, which was notified in the official gazette in 2020. This is a very landmark change in the consumer laws. So basically, now the consumer laws are based on 5 major principles: right to choice, right against marketing of hazardous goods, right to be informed about quality, quantity, potency, purity on price of goods; fourth, right to consumer education; and fifth, right to be heard and problems be adjudicated at different forums. These are the 5 principles on which the consumer laws of 2019 is based. Consumer laws of 2019 again have three-tier system. That is, again, the district forum, state consumer commission, and national commission. Except this three-tier system, there is another forum which is known as Central Consumer Protection Authority. I would first focus on what is Central Consumer Protection Authority, and then I would come on the three-tier system, which has been again followed in the Act of 2019. The Central Consumer Protection Authority is a quasi-judicial authority which would be dealing with the issues of class of products or class of services which is at fault. The Central Consumer Protection Authority has got vast powers under the Act of 2019 to even order for removal of particular class of products from the segment of the company. The order of the Central Consumer Protection Authority is only challengeable before the National Commission, and that too after payment of 50% of the award or determined by the Central Consumer Protection Authority, that is CCPA. So supposedly, if they have determined the losses at 10 crore rupees, so 5 crore has to be deposited before the Central Consumer Protection Authority before filing of appeal in the National Commission. So this has been a landmark change. The earlier Act of 1986 did not deal with the complete class or complete segment of goods or services. The Act of 2019 deals with it. This 2019 Act also deals with the issue of e-commerce. So e-commerce, since it was a three-tier system, as I told earlier, that product A is purchased from the seller, B is the facilitator to provide or to deliver the product to the actual customer, and C is the actual consumer or the customer for using the product. So this three-tier system is also covered. Now the liability of A and B, if a product is deficient, or there is the product is not properly of the quality which has been assured, A and B, both facilitator and actual seller, are equally responsible. You cannot say that if there is B is a delivery facilitator or an online app for purchasing the goods, he has no responsibility. He has to share equal responsibility if the product is faulty, or if the services is opted. Supposedly there are many apps on mobile now by which you order for a haircut or other or such person. The haircut is provided by person A who is the actual giver of the services. So if you are not happy with the services or the assurances or the quality which was assured to you was not offered or not provided, so the actual provider of service as well as the app maker is equally responsible under the Act of 2019, which was not under the Act of 86. This Consumer Protection Act 2019 also deals with misleading advertisement. earlier misleading advertisements were not part of Consumer Protection Act 1986. The Consumer Protection of 2019 says that supposedly if a builder has assured you of 20 amenities in its project and only 10 was actually offered, so that advertisement in newspaper or social media or internet is actual ground of suing the builder for misleading you to buy the flats or buy the commercial project. So earlier this was not part of consumer litigation. It was normally presumed that it was only a sale tactics. This does not hold within the four corners of law. Now they are responsible for the advertisements in which what they have stated, and if you are induced to purchase a product or purchase a service from the advertisements, from the services or the guarantee of benefits which it assures you, so you can sue them for misleading advertisements also. Now, one thing which I forgot to mention is what is the power of central authority, Central Consumer Protection Authority. Central Consumer Protection Authority have basically 5 powers. First is recalling of goods or withdrawal of services. Second, reimbursement of prices. Third, discontinuation of practices which are unfair and prejudicial to the consumers. Fourth, search and seizure of the places where there is deficiency in product or there is a deficiency in services. And fifth is direction and penalties against the false and misleading advertisement. So even if you are aggrieved by the misleading advertisement, you can also file a complaint before the Central Consumer Protection Authority. Since right now this act is very new, we would see in future how effective this authority would be. But as per from the bare reading of the procedure and the powers of the Central Consumer Protection Authority, it is a very powerful authority which would be coming up in the country. Now the 3-tier judicial system or the 3-tier quasi-judicial system is still kept intact. It is again divided. The consumer jurisdiction is again divided into 3 parts, that is district forum, state forum, and national commission. Though the pecuniary or the jurisdiction has very drastically changed. So if there is a dispute up to the amount of 1 crore rupees, it would go now before the district forum. From 1 crore to 10 crore rupees, the dispute would go before the state commission. And lastly, if the dispute is above 10 crore rupees, it would go before the national commission. Earlier, the determination of jurisdiction, pecuniary jurisdiction, was solely on the ground of the compensation which you have sought in the complaint, which has been changed in the Act of 2019. The jurisdiction is on the actual amount which you have paid for obtaining the product or services. So supposedly you have paid a premium of 5 lakh rupees against an insurance benefit of say 2 crore rupees. So your jurisdiction would be determined on the amount which you have paid. So you have paid a amount of rupees 5 lakhs towards obtaining that services. So if there is any dispute, it would go before the district forum and not before the state commission. But if you have actually paid a premium of say 1.5 crore rupees, then it would definitely go to the state commission. So the determination is on the actual price which you have paid for obtaining the goods or services. Only that will decide the jurisdiction. So earlier there was a timeline of 45 days for filing a reply, which has been kept intact in this Act of 2019. Now the time limit has been enhanced to 45 days. I would say that this 45 days period or the 15 days enhancement is better, for the reason that sometimes it is, in practical situations, it is sometimes very inconvenient to obtain all the certified copies within a period of 5-10 days, then give it to the another advocate for filing it before the state commission. It sometimes gets delayed. So unnecessary, then there is another application filed and then it is allowed. So it more or less prolong the process. So this 45 days period is sufficient. In the Act of 1986, there was no power of review. So supposedly, if the opportunity to filing reply or evidences is closed, so the concerned forums, except the National Commission, State Commission and the District Forum could not review its own orders. So it has to be challenged in the revision jurisdiction before the immediate next higher authority. In case of District Forum, it would be State Commission. In case of State Commission, it would be National Commission. Here in the Act of 2019, the District Forum and State Commission are also given the powers of review. Now, it is very important that this review power is given and is also exercised with due caution, because not giving the powers of review earlier had multiplied the litigations in quite a situation. So supposedly, if the reply is closed, so you have to file a revision petition immediately before the State Commission. So in that case, the State Commission would normally restrain the concerned District Forum to not proceed until that matter is adjudicated. So in that case, sometimes that litigation would go on for a number of years. Now, since the power of review is given, so supposedly if rightfully the reply or any proceedings could not be filed, an application seeking review could be moved, and that review could be allowed, and documents would be taken on record on cost on without cost as per the determination of the concerned judge. So this review has to be exercised very cautiously, but it is a very good step in the consumer litigation. Once the review power is given, it is necessary that it is exercised very strictly and according to the general principles of review, which has been set up, which has been given by the various high courts and the Supreme Courts. Now, except that the appeal, again, the timeline of 45 days is still there. You have to file an appeal within a period of 45 days. The National Commission appeal has to be filed again within a period of 45 days. There is a provision of second appeal also under the new Act of 2019, but that is only specifically on the question of law. The question of facts cannot be placed in the second appeal. In my personal opinion, the second appeal provision should not have been placed in the Act of 2019, as it might delay the litigation. But we will only see in the due course what is the effectiveness of the provisions of second appeal. The powers of revision petition still exist before the State Commission and the National Commission. The compensatory part, since the pecuniary jurisdiction of both District Forum, State Commission, and National Commission, all three forums have increased. So the power of awarding financial penalties have also increased in all the forums. Now, since the 1980, in the Act of 1986, there was no provision of electronic filing, and with the changing times, especially in the COVID times, there is a provision which has been put in the Act of 2019, in which electronic complaint can also be filed through electronic mode. This is one of the first legislations in India which in the statute itself provides for electronic filing. Normally, it is prescribed in the procedure book or the procedure handbook of various legislation or various authorities which do their concerned work. But this is the first enactment in which the electronic filing is prescribed as a statutory provision. So I hope that the principle of electronic filing is very strictly followed, so that a lot of paperwork is saved, unnecessary paperwork and unnecessary damage to the environment is saved. The limitation under the Act of 1986 and under the Act of 2019 is 2 years. That is from the date of incident. So the complaint has to be filed within a period of 2 years. If for any case the complaint could not be filed within a period of 2 years, it has to be accompanied with an application under Section 5 explaining why there is a delay in filing of complaint. So the general limitation for filing a consumer complaint is 2 years. Again, the compliance of the order under the Consumer Protection Act of 2019 is a punishable offense under Section 72 of the Consumer Protection Act, and the award or the order of the consumer forum can be executed like a civil decree, or if it is not still been implemented by the concerned respondent, this is a punishable offense with an imprisonment up to 3 years, and with a penalty of from 25,000 to 1 lakh rupees as a fine. Now, the one point on which I personally feel the Consumer Protection Act 2019 is still lacking is on the issue of pecuniary jurisdiction. District forums are already overburdened. They are having lack of infrastructure, more or less. There was a committee set up by the Supreme Court in one of the SLPs which had thorough investigations of the infrastructure facilities of all consumer forums across India, which was headed by a retired Supreme Court judge. And almost 80% of the district forums were found having less infrastructure or improper infrastructure in dealing with the consumer complaints. Either the manpower was less, or the building infrastructure was too less to deal with the complaints. I feel that by putting the clauses of actual payment as determination of pecuniary jurisdiction over filing complaints, they have more or less overburdened the existingly depressed district forum. So until unless they provide better infrastructure, better manpower, financial independence to the district consumer forum, the intent of this legislation of 2019 will not be accomplished. So I very sincerely believe that there will be a step taken by the concerned state governments and the union government for benefits of the consumer. But I sincerely feel that this particular provision still needs an amendment, and like earlier, the consumer complaint or the jurisdiction of filing consumer complaint should be determined as per what has been sought as a compensation in the complaint. But let us hope this whatever happens will come to know in the near future. But right now, these are the basics of the consumer laws. I have covered in my session almost all the provisions and the aspects of consumer laws. I would be now informing you about few landmark judgments of the Consumer Protection Act. The first is Om Prakash versus Reliance General Insurance. It was reported at 2017, Volume 9, SEC 724. The intent of this judgment is that insurance company cannot reject claims or technical grounds. So what used to happen is, so supposedly if we have taken an insurance policy for, say, car accident, you met with a car accident, there is a clause that the incident needs to be reported before the concerned police station within a period of, say, 5 days. But you did not report it within a period of 5 days. You did it, probably you met with an accident, so you had some physical difficulties, and you did it after 10 days. They would reject your claim, saying that the clauses or the clauses of the policy or the conditions of the insurance contract was not followed. The Supreme Court came heavy upon all the insurance companies and stated that insurance company cannot reject claims on technical grounds. It has to have very solid proof as to why they are rejecting or they are repudiating the claims, because ultimately it is a beneficiary legislation. Consumer is a beneficiary legislation, and if the companies are finding a way to not pay the compensation part or not avoid their liability for a period of, say, 2 years, 3 years, in order to gain unnecessary financial benefit, it is more or less a cheating. So the Supreme Court says that these technicalities cannot be read against the consumer. Second is the National Insurance Company versus Hindustan Safety Glassworks Limited and another. It was reported at 2017, Volume 5, SEC 776. This says that the provision of limitation in the Act cannot be strictly construed to a disadvantage of a consumer. So normally what happens was these 2 years. So for supposedly the consumer is not a literate one, and they did not know about the time limitation of 2 years, and somehow they came to know through some channel that they have been cheated and they have a remedy for it, and already 3-4 years have lapsed. So such complaints were repudiated or got dismissed on the grounds of limitation. The Supreme Court says that the provision of limitation in the Act cannot be strictly construed into the disadvantage of a consumer. So it is a very beneficial judgment in favor of the consumers by the Honorable Supreme Court. Third is Messrs. Imar MGF Limited versus Aftab. It is reported at Civil Appeal number 23512 of 2017, or the alternate citation is 2019 volume 12 SEC 751. It says that if there is an agreement, it is particularly in the builder-buyer disputes, that if an agreement which has an arbitration clause, the consumer forum will be the appropriate forum for hearing the dispute. So supposedly, if you have entered into an agreement, there is an agreement between A and B, and there is an arbitration clause. Even then, any party can file a consumer dispute if there is an unfair trade practice, or there is a violation, or there is a deficiency in product and services. Just having an alternate remedy or an alternate adjudication remedy does not bar the consumer jurisdiction of the consumer forums to entertain complaints. This also has been held in judgments where the builder have challenged that since the appropriate remedy is before the RERA, that is the Real Estate Regulatory Authority, the consumer complaints is not maintainable. The Supreme Court held that the consumer protection is a specialized law in which the consumer complaints would be maintainable, just for the reason that an alternate remedy is provided does not bar the consumer forums to entertain a complaint. So it is a very landmark review which almost gives you two remedy to contest a case. You can suppose if there is a builder buyer dispute, you can file it before the RERA, you can file it before the concerned consumer forum as well. For this particular judgment on RERA, the citation is Ajay Nagpal and others versus Today's Home and Infrastructure. It is the citation of the National Consumer Commission cases, CC number 1764 of 2017, in which it was held that RERA Act does not bar filing of a complaint under the Consumer Protection Act 1986 against a builder or a developer. In this judgment itself, the Honorable National Commission reiterated that there was no provision in the CP Act 1986 which was inconsistent with the RERA Act 2016, and that both the legislations are supplemental to each other, and therefore did not notice any preliminary issue regarding maintainability of complaint filed under the CP Act by the allottee and buyers. So the effect is that from this judgment, we can that the only option to file a case in consumer complaint, but also can be pursued before the RERA. One thing which I forgot in my own section is that even the medical negligence is also included in the consumer laws. So supposedly you went to a hospital to get yourself treated, and you were assured of certain services. I'm not talking about assured of giving you good health, assured of certain services. Or supposedly you went through a surgery which was not rightly done, or the basic precautions under the medical science was not observed. In those particular cases, this was considered as deficiency in services, and these medical negligence cases can also be filed before the concerned consumer forums. However, there can be no guarantee or no cure, no success in a medical negligence case. So if you say that I was guaranteed by the doctor to get myself cured, this is no ground for filing of a consumer complaint. You can certainly say that I had to go through a surgery of the left hand and the doctor wrongfully did it of the right hand. That is certainly a medical negligence. But if you say that I was assured that I would be fit and healthy in another 10 days, and it took me 1 month, so that is certainly not a medical negligence. Another one last judgment is Supercomputer Center versus Globis Investments. This is a judgment of 2006, which was passed in revision petition number 1086 of 2006, which says that the complainant, though bought the goods for commercial use, the consumer complaint is still maintainable as the defect period has arisen within the warranty period, and thus the purchaser company comes under the definition of Consumer Act. So the definition of consumer means he has to consume the services. So even he has consumed the services for livelihood, and there was a warranty or a guarantee period assigned to him for a period of 2 years, and defect has arisen during this period, even then the consumer complaint would be maintainable. From 1986 onwards to 2020, there are catenary of judgments which has more or less increased the scope of consumer litigation or consumer laws or consumer beneficiary legislation in India. So even though there are certain exceptions to it, but those are very thin line differences which can be taken care of through the pleadings which you draft while filing a complaint. Though the option of filing a complaint through an association, through yourself, or through a set of persons which you want them to represent can be done, but it is always advisable to take opinion from legal experts before filing a consumer complaint. So this was my session on the consumer laws. Now I'll leave the platform open for everyone. If they have any query, I would be happy to answer that. Over to you, Abhilash.
Yes, students, do you have any questions?
Sir, in India, Consumer Act is very deliberate, very lacking because of there is no infrastructure or delay of the judgment, sir. What is the reason, sir?
The delay in judgments, or the delay or the lack of consumer litigation or delay in the process is because of the infrastructure. The law is very well propounded. The provisions of law is made as such to adjudicate the disputes as early as possible, but due to lack of infrastructure, there is a delay on part of adjudication process. See, the infrastructure is first the responsibility of every state. So every state has its own notions of infrastructure for providing it to the concerned consumer forums. There is a severe infrastructure deficiency or deficit across the nation, that I would very frankly admit.
Yeah, Nitish sir, in Bangalore we have a very good setup of consumer courts here. Okay. For Bangalore urban, we almost have 5 courts, which is situated in Shantinagar bus stand. For Bangalore rural, the consumer complaint has to file before in the court is situated in Kaveri Bhavan. There is very good setup in Bangalore. I think all capitals of all states need to set up their own private courts for consumer. I think only in different districts it is limited to the district courts.
What I felt is that infrastructure at the state commission level is better, good. Yes. But at the district forum, if you leave aside the capital cities, or I would not say not every capital city, the infrastructure in other districts are not so good. Even if you see in Karnataka also, I believe if you go out of Bangalore, rural or urban, you would feel that there is a lack of infrastructure. The same exists in Delhi. Same exists. The best infrastructure in this district forum, which I've seen, is I think of Maharashtra. Except that in most of the states, there is a severe lack of infrastructure facilities.
One more fact I want to state here is recently I filed I think two consumer complaints before State Commission.
Okay.
But just when I filing just after a week, there was an amendment in the change of pecuniary jurisdiction.
Correct.
The prayer what I sought, was for fixed. I think it was more than 1 crore. I
Okay.
asked before State Consumer Forum, and they asked me to file again, go back and file before District Commission, because now District Commission has more powers. I think.
Already registered before the Act of 2019 was notified.
No. I think recently there was an amendment. Last year only there was an amendment.
The Act was notified in 2020. That
2020.
just give me a minute.
Yes.
Exact date of notification is 23rd July 2020.
Okay. Earlier, up to 20 lakhs, it was, I believe, District Forum. Now up to 1 crore, it is District Forum.
Yes, correct.
Yes.
But supposedly, if before 23rd July or before the date of official enactment, if you have already filed a complaint before the State Commission, it need not be,
No, actually, the State Commission, it was posted for hearing. Just after 1 week of they getting that amendment, they asked me to file before District Forum. They asked me to withdraw my complaint, and I had to refile before District Forum.
It must not have been registered by then, so that is why you had to be relegated to the District Forum for.
Yeah, I got the complaint registered. I got a case number. When I approached State Commission Forum for hearing, they asked me to withdraw my complaint, and I had to file before District Commission.
That order is incorrect. So if the case is already registered,
I think these judges did not want to take it in their all. Yeah.
That is a separate thing. But the National Consumer Commission is very clear that up to the date of notification, if there is any particular complaint which has been filed in jurisdiction of State Commission or National Commission, that may not be relegated back to the new pecuniary jurisdiction as per the new pecuniary jurisdiction. It may be entertained and dealt with in that particular forum.
Yeah, only those cases where the trial has started and evidences have been submitted, those cases were allowed to stay in State Forum. But those cases which had just filed and which were put up for hearing, all cases including me were like arm twisting. They did some arm twisting and asked us to withdraw our complaint, and we had to again.
I think, in my personal opinion, that was not the right practice.
Yeah. Correct. Yeah. Any questions, Rupesh?
Yes, sir. Hello, Nitish sir and Abhilash sir.
Hi.
Yeah, hi. I'm from Bangalore, Teachers Law College.
Hi, Rupesh.
I have a quick question. So you said pecuniary benefit or compensation.
Yes.
So is it with respect to the services that you availed or the products you purchased, or you can claim or you can request the concerned consumer court for higher compensation? For example, I read an article in US. So some guy purchased a Coke and he found some worm inside the Coke, and he requested their district or state commission for like in $1 million. So will that be entertained in India also, or in what cases we can avail that service?
Yes, this can be done in India also. So basically, when you seek a compensation, it is basically only in the three heads. First is the amount you have paid to obtain that good or services. So supposedly you have paid 1,000 rupees to obtain a particular, say, I'll put give an example as a sweet. If you went to a sweet shop and bought a particular sweet which costed you, say, 700 rupees kg, so you would be seeking compensation for refund of 700 rupees. Second, you will be seeking compensation on the grounds of harassment or mental harassment. Say that that product was not right, or that had particular germs or bacteria which had ill effect on your body or on your health. So you may be seeking compensation of 50 lakh rupees or 1 crore rupees up to 1 crore rupees under the act if you want to file it before the district forum, saying that this amount may be given to me as a compensation, and then you will be seeking cost on the physical harassment if you are admitted to hospital, then the hospital bills as well, and lastly the litigation cost. So supposedly if you have paid fees of rupees 50,000 to an advocate for contesting the dispute, and you can see that litigation costs as well.
Okay.
Basically, these are the tort laws. These laws are based on the torts. So these are all more or less similar across various jurisdictions in the countries or among various countries.
Okay. Okay. And we have to justify our statement before we claim that.
Yes, yes. Yeah, there has to be a strong reasoning. Certainly, you have to say that, supposedly you got ill and got admitted to a hospital, and it took almost 10 days to 15 days to recover. And in the meanwhile, you were fired from your job. So that is a very reasonable explanation for seeking a compensation of 1 crore rupees.
Okay, that makes sense, sir. Thank you so much. That is, it was a very valuable information, sir. Thank you so much.
Thank you.
Yeah, basically, you should have suffered some loss of any service or any product you have obtained from a dealer
Okay.
or a service provider. So
Okay.
that is the main condition you have to prove before the consumer forum.
Correct. This is basically a social welfare legislation. You cannot derive profits out of it, but you have to show that you have suffered certain losses because of the deficiency in services, deficiency in the product, or unfair trade practices.
Okay.
Hello, Mr. Nitish.
Hello. Hi there.
Hi. Okay. Thank you very much for the excellent seminar which you have given, and today's was it is very important. I just wanted to ask one question. So today's the e-commerce Consumer Protection Act is adequate to answer or provide the relief if any consumer or customers face any problems. So take an example, if you buy any product from Flipkart, they will exchange the product, but they will not do the refund. But the same case, if you go to the Amazon, they can refund you the money also, other than the exchanging. So why this kind of differences between the two service provider, and how adequate is our system?
See, the issue of refund and replacement, it is an individual company policy. One company can choose to, refund the whole amount, or another company can choose to give a replacement. When you talk about the legislation, or when you talk about how proper is the Consumer Protection Act to deal with the issue, it is a very strong legislation. Among the various laws of consumers in a number of countries, India has one of the very strong laws to deal with the Consumer Protection Act. And particularly in the Consumer Protection Act 2019, e-commerce is a part of it. So earlier what used to happen is the only guilty person would be the actual provider or seller of the services. Now even the facilitator of services, so you have ordered a product A from some online mobile app, and it was not delivered, or the substandard quality of product was delivered. So the facilitator of that services is also equally responsible for paying you the compensation. So just in case, I'll give you a reverse example. So if you have ordered from, say, one company which do not offer refund and have only a replacement, and they're not on replacement also, you are not getting a proper quality product which you have seen in the mobile app, you can file a consumer complaint against both the facilitator, that is the mobile app which is serving as the facilitator between the seller and the consumer, and the actual seller. Actual seller name is always provided in the app. If you scroll down on all these mobile apps, you will find that the name of the actual seller is always given. So you can file the complaint against both of them, and I assure you, if it is a substandard quality product, you will be getting necessary compensation. So, regard to your query regarding why these companies have different policies, yes, that is an individual company practice over which no jurisdiction or no law can have a control. I'll give you an example. Today, if a client is not satisfied with my services, I can offer to refund the complete fee which I have taken from him, and some other lawyer might choose that you do not pay the rest of the fees, and what I have taken towards my services will be charged towards what I've what services I have already offered you. So those are the individual policies of the companies. You have no control over with. But if there was a certain quality product which was offered to you or assured to you and was not provided, the laws are very well in place to deal with such situation in India. It might
Thank you very much.
some time. It might take some time depending on the jurisdiction, place, and the infrastructure. But laws are well drafted to take care of that situation.
Thank you very much, Nitish. I have one more question. So I purchased a flat in 2013 and builder promised to provide Kaveri water. It is very well mentioned in the brochure and in the sale agreement, but builder has not provided any infrastructure. Now builder is refusing to provide any infrastructure and all those things. So after 7 years, do I have a right to approach the consumer court for the relief?
Yes, you have. See, it is a continuous cause of action. Cause of action normally is of two types. One is that stops from the purchase, supposedly you have purchased a good. From day one, it was bad. So you could have filed it within a period of 2 years. But if you have purchased a flat or a services from a third party which is continuous in nature, you have to reside, and on daily basis you are facing problems in regards to the services which are assured to you and is not being given to you, then certainly you can approach the concerned district forum. All you have to show is that there is a continuous cause of action arising out of the negligence or the unfair trade practices followed by that particular builder.
I would just like to add a few points, Nitish.
Yes.
Suppose the Dharamji, if Kaveri lines have come in your area for water supply, then the builder has not provided. You can approach consumer forum. Consumer forum will give you a remedy against for all the losses and other grievances you have suffered. Suppose in the situation where Kaveri lines has not put up by the government, then the court will say wait till the government wait till the government gives water access to all people in your area. This is the stand. And in one more example I would like to quote, wherein a person entered an agreement with one of the builder, and the builder had not mentioned a completion date when he would come forward to provide the plot which he will develop. For example, he has showcased the pamphlet stating that he will be selling and people can come and invest in it, not buy the plot. Invest so that he develops and gives it. And he has not mentioned a timeline when he will complete it. In a similar case, that I witnessed the judge saying that you wait till the project get completed and then because there is no timeline mentioned in your agreement, this court cannot help you. This was the stand taken by the government.
I think I have a different view on that. There was a recent judgment of Justice D.Y. Chandrachud, which says that first, in a builder-buyer contract, date has to be very specific. There has to be a completion date. Without completion date, that agreement is itself void. Second, these one-sided clauses, where the court have termed it as a one-sided clause, which says that the builder has, put certain conditions which are one-sided and favorable to him, are itself void. Those one-sided terms of the contract or the clauses of the contract is itself bad in law, needs to be read down by the concerned RERA or by the concerned consumer forum. So I think this cannot be a situation that a builder has promised a particular development of a land and he do not do it for say 30 years. So why have you, supposedly for investment purposes also, if they don't develop it for 30 years, your money is already stuck. So in order to get a return, or in order to earn your livelihood, or in order to actually reside in that issue, in that plot, or in that area, that period has to be very definitive. This was held by the Supreme Court, and I don't remember exactly the case name, but the judgment was passed by Justice D.Y. Chandrachud.
Yes, I remember this case. I think this scenario I am explaining maybe before the judgment came in place.
Correct.
This was the stand by all consumer forums, if because people were innocent.
Correct.
And builders used to fool without putting the completion date of allotment or other things.
Correct. Absolutely.
Yes. Further questions, Rupesh?
Thank you very much, Abhishek and Nitish.
No, sir, that's it for now.
Yeah. Any more questions?
Sir, I have a question. I'm Navya.
Hi, Navya.
Yeah. Hello, sir. Sir, all this time you have talked about builders and like commercial activities. I want to know whether this educational institution also come under this consumer forum, because
Yes.
sometimes education institutions are also involved in commercial activities like selling books, or perhaps engaging some software companies like like many apps like My Children's School. They provide an app called MindSpark for maths, and the same app has been provided in some other school for a lesser price, half the price, but my school is charging the double the price. So can I go about and file the suit against the school and the company which is providing the app?
Educational institution, coaching institutions, these are covered and not covered both. There is a very thin line of differences in the cases where you can file a consumer complaint and where you cannot file a consumer complaint. Coaching institutions or the educational institutions cannot guarantee you, even if they put it as as a misleading advertisement, they cannot guarantee you a success in a course or in an education. But in the given circumstances which you have told, where a particular product is being offered to you double the price compared to other schools, yes, it is a case of unfair trade practice. It is not deficiency in service, that is not defective good, but it is a case of unfair trade practice.
क्यों नहीं कपड़ा पहने हो?
Are already overcharged.
हैं?
मेरा जन्मदिन अपने आप में एक फूल है, पैदा ही नहीं होना चाहिए था।
Sanjay, please mute Dharam.
Mr. Dharam, please mute your mic, please.
Sanjay, your host, you can mute him.
Okay, sir.
Yes.
I answered your query, or is there anything more which I can add?
Yes, Navya.
Yes, I got the answer, sir.
Yeah.
Thank you so much.
Welcome.
Hello, sir.
Yes, Rup.
Hello. Yeah, hi. Nitish, sir. You
Yes.
have mentioned regarding the Central Consumer Protection Forum.
Correct.
Yeah. When can a person directly approach, or do he has to follow the regular procedure, like first district, then the
Central Consumer Protection Authority. So basically, it is there are two vertical channels. One is the quasi-judicial channel, that is the district forum, state forum, and the consumer forum, and the second channel is the Central Consumer Protection Authority. So you can directly certainly approach the Central Consumer Protection Authority if there is any difficulty, or there is any deficiency in goods and services, or there is an unfair trade practices being done by the seller or the manufacturer of the particular product.
Okay, we can use both the ways. Directly, you can approach consumer.
You have to choose either of the ways.
Okay, fine. Okay, sir. Yeah, I got it.
Sir, I have a question. Thank you very much for this presentation. It was very much helpful. I
Yeah.
have a question. Do the medicines or the drugs what are available in the market is covered in the consumer forum?
Yes, if they are of substandard quality, they are covered under the consumer protection laws. But just if if somebody assured you of a cure that you will 100% be fit and fine if you consume a particular medicine, or you find in numerous advertisements and newspapers certain medicines prescribed for weight and height. So those are misleading advertisements, which can fall under the criteria of consumer laws. But if you say the doctor has guaranteed you a cure, that doesn't fall within the criteria of consumer laws.
Sir, a very simple example. When we take a syrup, right, a suspension syrup. So what usually happens is when you take that syrup, at that time, the the color of the syrup is different. But if you store in a particular temperature, the after a few days the color changes. It becomes a discoloration. So are this usually covered under consumer forum if it is not declared in their leaflet?
The change of color does not reflect that it has some side effects, or it does it the cure or the property of curedness is reduced. You have to show that this particular syrup was of substandard quality. If you are able to show that, yes, you are covered under the Consumer Protection Act. Otherwise, no.
Yes, Chanakya, I would just like to add, Nitish, Chanakya, you would have to appoint a chemical expert and check its chemical composition, how it works. You have to do some background work about the medicine. You have to submit that proof before court, because the judges are also not experts in deciding whether this medicine will work or not.
Correct. I am totally in favor of the views.
Because what happened in one of the cases where a Ford EcoSport, it met with an accident. It just went into a hole and its flat got burst, and the airbags did not open. The car toppled twice and it fell into a ditch from the bridge. And luckily, both a husband and wife survived. In this case, I lost this case for the reason because the complainant could not get an expert opinion about how the accident happened. This was the only deficiency. Due to lack of this, the accident can be natural in nature, and already he has obtained insurance claim out of the vehicle. So this deficiency I could not prove before the court because of lack of expert evidence that why the airbags did not open on time.
Sir, who could be the expert?
Yes, to add to what Abhilash said and to answer your query, you can file an application. Supposedly, you are a certain panel of doctors or experts in that particular industry. You can file an application before the concerned consumer forum saying that this is my thought, and this product, as per me, is a substandard quality. And in order to better address this issue, I propose the name of XYZ person to be appointed as an expert for adjudicating this whole issue. The consumer forum, at the cost of the respondent or the company, can appoint the expert for addressing that particular issue.
So at the cost of the complainant, or
the cost of the respondent company. They can also give equal share or equal distribution of his fee or his professional services, but normally the cost is upon the respondent.
okay, if the complainant is totally illiterate, so every time a complainant could not be a literate person.
See,
so
you don't understand the chemical composition. I don't understand the chemical composition, or even a normal advocate would not understand the chemical composition. In such situations, it is always advisable that you file an application, get an expert that report.
Okay.
Sir, who could be the expert? Like, will it be a government official or any dignitary from?
Be a person who's well acquainted in that particular product or in that particular industry.
So laboratories are available. Certified laboratories. Yeah.
Yes, certified laboratories. In case of accidents, there are private investigators or independent investigators who are also engaged by the insurance companies. They can also be placed as an expert in the panel.
Can the complainant find an expert and get the expert opinion, or it has to be always appointed from the court?
Yes, you certainly can get an expert opinion. It has to be sealed and verified. But the credential of that expert has to be foolproof.
Okay, sure. So thank you very much.
Yeah. Any last questions from the audience? Yeah. Rupesh.
No, sir, it's fine. I'm good.
Sir, I have a continuation question to this because recently we have a launch of particular vaccine, right? So India has launched this particular vaccine, and few people are taking vaccine, and they are getting again the infection is getting to those particular people who has taken the vaccine. So can those people file the case against the particular?
The vaccine itself states that this is no assurance that you will not contract COVID again. This is only giving you an immunity or a boosting antibody so that you can fight with that disease in a better way. It doesn't say that you will not contract. The government as well as the private have very well stated that it does not assure you that you will not contract COVID. It is only giving you an aid to fight the disease.
But sir, government websites and everybody they are saying that if you take these vaccines, you will not get the COVID.
No.
In the layman term.
That it is necessary to fight for COVID.
Okay.
Chanakya, it is just like you signing undertaking form with the university that any decision from Supreme Court that university is not responsible in case of the age limit.
Okay.
It's just.
So, sir, bottom line is like if the company can declare that this product, if they declare, then they cannot be sued, right?
Yes, if they are voluntarily declaring that we do not assure you 100% good result. So if they are in this case, they have said that they do not assure you that 100% manner that you will not contract COVID in case you take the vaccine. That means there is a voluntary declaration by the company.
Yes, you cannot hold a company liable when they voluntarily declare. Even in many emergency medical operations, the doctors want you to sign an undertaking form that we are not responsible in case of any death or any permanent injuries from the operation itself.
Yes, before any operation. Yeah.
Yes. It's like that.
Sir, adding on to Mr. Abhilash, sir, you said regarding the EcoSport case, right?
Yes.
I have a small and quick question. So you said you lost the case because of lack of expert opinion.
Correct.
Yeah, I think in any of the car manual they have not mentioned like airbags will open only in certain criteria.
Yeah, it is mentioned actually. What has happened? He is going above the speed of 20 kilometers per hour.
Okay.
He's going at the speed of 80 or 90 kilometers. He bumped, and the right side of his car dashed the bridge wall, and it flipped twice and fell into the ditch, crossing that wall.
Okay.
Because it meets all the parameters, how the airbag should open. The front bumper, when it is dashed, it automatically it has to send a sensor and it has to open. What has happened in my case was this guy repaired the car after this thing without getting it investigated, how the accident happened and all what all circumstances led to the accident, and he sold off the car.
Okay.
So we did not have that crucial evidence investigation done why the airbags did not happen or did not open at that time. So due to this lack of evidence during the time after the accident, which our complainant could not get it done because they were in a shock. They wanted to sell the car immediately after recovering.
Okay.
So this is the reason we could not convince the court.
Okay. So basically, complainant should be prepared if he really wants to file a complaint, and he should get a expert opinion before he gets that repaired.
Yes, he has fully claimed insurance of the vehicle for all the health and other damages. But
Okay.
in the deficiency of service was the airbags did not open
Okay.
with the proper manual of how the airbag under given circumstances, the airbag should open on a given conditions. All conditions were met, but it was not the complainant did not investigate after accident why the airbags did not open. He got it repaired. He got it repaired in a fully clean. He made it in a fully clean car, in a new car, after claiming the insurance for repair and other things.
Okay.
So this lack of evidence we could not prove before court. This is one reason. Yeah.
Thank you, sir.
Any last questions? Yeah, we are coming to end of the session. Nitish, I would like to thank you for this wonderful informative seminar. We thought that we would discuss, and our discussion went on towards vaccines, medical industry also. We discussed various areas, which is very much knowledge sharing and very informative. For all the people who will watch this video in YouTube also, they will learn many things out of this video. I'm definitely sure about this. So thank you very much for a very awesome seminar, I will say.
For giving me this opportunity to speak on the issue of consumer laws. I am thankful to you.
Sure. So thank you, everyone. Thank you all students for asking very important informative questions from your side. You asked very important questions. That was very important for this seminar. And we thank all the students also for contributing. So thank you, everyone. We come to the end of this session. Thank you, Nitish. Yeah.
Thank you, sir.
Yeah. Thank you, sir. Thank you, everyone. Thanks.
Yes, sir.
Thank you, sir.
Thank you.
Thank you, sir.
Thank you.
So I'll just end this session, sir.
Yes.